With this material, we begin our overview of the substantive law of employment. And what I think is important to understand about employment law is it's really the intersection of the law of contracts and the regulatory structure and the role that government plays in regulating certain types of behavior, notably certain types of contracts. At its core, the employment relationship is a contractual relationship. An employee works for the benefit of the employer with a agreed upon compensation structure for that employee paid by the employer. But I would make the argument that of all the different types of contracts that we have in society, that there is perhaps none more significant than the employment contract. Most of us are not independently wealthy. Certainly, most of us are in need of the ability to have access to health care benefits and health insurance. And as a society, we wish to certainly promote the ability for someone to exist without the necessity of the safety net that is provided by the government and various different governmental resources. We want people to be able to be self-sufficient, and we wish for people to have the opportunity to have employment based upon their ability to provide the skills that they have for the betterment of a business that they can work for or a business that they can perhaps create. But we wish for there to be a self-sustaining aspect of a person's life, certainly during their core working years. And so the employment contract, as important as it is, results in certain regulation of the contract for what is perceived to be in the best interests of the society. And this is where I say that we have the intersection between the law of contracts and the law of regulation. There is always the ability or hope within law that there is that balance between what's in the best interest of an individual and what's in the best interest of a society. And so we recognize that while we allow for the freedom of contract, the ability for someone to pick and choose what type of contracts that they wish to enter into. You can buy whatever car that you want to. You can select whatever school that will admit you that you wish to attend. You can pick whatever store that you wish to shop in. But there are certain types of contracts that we do put some limitations on the freedom of contract. And one of those types of contracts that we place some limitations on the freedom of contract is with employment contracts. We do not want to allow employers to pick and choose freely who they wish to employ without placing some limitation, some regulation upon those freedoms. And this is for not just the benefit of individual employees, but also for the benefit of the employer, for the society itself. We recognize the concept or the idea that birds of a feather will flock together. Well, within an organization, within certainly a business, there is great benefit that is seen by having persons who are certainly of different gender and different skin color and different background and different ethnicity. We recognize that organizations thrive when you have difference of opinion, and while there might always be an inclination that we wish to associate with people that think and look as we do, that can be a temptation that exists, that there is a great benefit for ourselves and for our organizations when we do have a collection of individuals that are members who have varied backgrounds and certainly cannot be classified or characterized the same way, other than being a part of the populace. And so we do place certain limitations on, if you will, the freedom of contract upon employment contracts by having certain statutes that regulate our ability to discriminate upon who shall be and can be included for purposes of employment. We'll talk about some of the most significant statutes that regulate the employment relationship. We recognize that there needs to be a limitation on the work week. There needs to be a limitation on how low we will allow for payment to be. So we have safety statutes that regulate business. We have hour and wage limitations that place regulations upon business. And so while the employment relationship is a contractual relationship, it is not a contractual relationship without certain limitations that are imposed by statute, by law. At its core, the employment relationship is a contractual relationship that comes in really three different types. There's three different options for purposes of characterizing the employment contract. The first of these is what we refer to as the fixed term employment contract. The second is what we refer to as the employment contract that is at will. And the third way that we can classify an employment contract is an employment contract for a period of time that is referred to as a just cause employment contract. And all employment contracts will fit into one of these three classifications. Anytime that you have a job, your employment relationship will be classified either as being for a fixed period of time, a fixed term contract, a contract that is at will, or a contract that is said to be or classified as a for cause or just cause employment contract. And I'll tell you something right from the outset that I do want you to remember. In fact, perhaps the takeaway from the lecture on employment law is as follows. If you are ever anything other than an employee at will, you will absolutely always know it with certainty. If you are ever anything other than an employee at will, you will absolutely always know it with certainty. In other words, the fixed term employment contract, and certainly the for cause or just cause employment contract are really exceptions. The standard fallback position, if you will, the backdrop to all employment law, the presumption when we have employment is that the employment contract is said to be an at-will employment contract. And we'll talk about what that means as we move forward. But I, again, reiterate, and I think this is very important. And in fact, I've always seen people surprised when I meet with them, particularly when they've had some form of negative event happen within their job, likely that they were demoted or that they lost their job. They're always a bit surprised that they're an employee at will, particularly when they somehow were led to believe or allowed themselves to believe that they were something other than an employee at will. Most of you, believe it or not, most of you will go through your entire careers in employment and you will be employees at will. And recognizing this is important. Certainly understanding how we regulate the employment relationship that is at will is important. If you will, the statutory exceptions to the employment at will doctrine. But I will say it one last time. If you are ever anything other than an employee at will, you will absolutely know it 100% of the time. So if I may, let me go to the lecture slides, and I will be utilizing this method as we go through our discussion of employment law. You'll look at my slides and see a little bit less of me. And hopefully I can find those lecture slides. And here's our starting point. The nature of the employment relationship is that it is a contractual relationship, the contract between employer and employee, and that contract of employment will fit into one of these three classifications, always. You should, in fact, train yourself always when working for another to know, is this a contract that is for a fixed period of time? Is it a contract that is for an indefinite period of time that can be ended by either party at any time for any non-unlawful reason, what we refer to as a employment contract that is at will, or is it an employment contract that is characterized as being terminable for just cause? All employment contracts are going to fit into one of those three categories, the most significant of those categories being the employment contract that is at will. But let's look first at the employment contract that is for a fixed time. A fixed term contract is a contract that has not just a beginning date, as all employment contracts do, but also has a fixed end date. We know that we are being hired for a particular task and our employment ends at the conclusion of that task, or we know that we are being hired for a particular time interval, and we know from the beginning when that contract is coming to an end. There is a date upon which the parties have agreed that the contract is going to end. Now, one of the things that I ask you to remember from the overview of contract law is that not all contracts are memorialized in writing. And in fact, many an employment contract actually will not be memorialized in writing. It's not that it shouldn't be memorialized in writing. It's just the fact that many times an employer will hire a person to come work for the employer and not actually have a written employment contract in place. There may be an employee handbook. The employee may be asked to sign certain documents acknowledging receipt of the employee handbook, designating whom the beneficiary of employer-sponsored retirement policies or programs might be. The employee may be asked to sign a non-competition or a confidentiality agreement. And in fact, the employee may indeed have a written memorialization of the terms of the contract that is in fact a written employment contract. But the vast majority of employees actually will not have a memorialized written employment contract because the vast majority of employees actually are employees at will. When you have a fixed term employment contract, it is more likely that the terms of the employment contract will be memorialized in writing, largely so that the employee does know at the onset of the relationship when the employment contract is going to end. And don't be confused about the fact that even though there is an end date, the employment contract that is for a fixed term very well will include provisions that would allow for the employer to terminate the contract for certain objectionable behavior on the part of the employee. And you'll see that outlined in the terms of the fixed term contract. This is when the end date is, and we will no longer be responsible for making payment to you. However, if you engage in these behaviors, these types of activities, the employer reserves the ability to terminate the contract early without further need for payment pursuant to the terms of the contract. One of the things that I always urge employees to be cognizant of is when a written employment contract will hold a provision wherein either party can terminate the contract with, say, 30 or 60 or 90 days notice. Through my career, I have read many times fixed term employment contracts for physicians who are being hired to work for hospitals. And what is noteworthy in those fixed term contracts is they usually compensate the physician quite well. And almost always the fixed term employment contract will call for a fixed period of time of, say, 2 years or 5 years. But most of them, not all, but most of them will also include a provision that allows for the employer or the employee to terminate the contract upon 90 days notice. And so most recently, I reviewed a fixed term employment contract for a emergency room physician who was taking a job with a hospital. And it called for pretty good compensation, I won't lie. And it said right at the top, 4-year employment contract. But I noted and brought to the attention of the physician paragraph 22, because paragraph 22 said quite clearly, this contract can be terminated by either party with 90 days written notice to the other party. And so I explained to the physician, while this looked like a great contract and a nice compensation package, and that I certainly was not objecting to the physician signing the contract, the physician did have to note that really at its core, this was an employment contract guaranteeing no more than 90 days of employment. Because at any time during the term of that fixed term contract, either party, including the employer, could terminate the contract with 90 days notice. So in other words, there was a point when the physician could show up at work, the employer could say, here's a check for the next 90 days of pay, don't come back tomorrow. And they would be within their legal right to do that. The other thing with respect to fixed term contracts is do not confuse a fixed term contract, a start date and an end date. Don't confuse these provisions with what we refer to as probationary terms of an at-will employment contract. When you get through with your education, you get out into the work world, or if you're already out in the work world, you change and take on new employment with a different career employee, or rather employer. Don't be surprised if that employment contract has a probationary period, 30 days, 60 days, 90 days. And all that says is, and all that means is that before any of the benefits to which you are entitled pursuant to that contract would apply, you must actually successfully complete 30 or 60 or 90 days for those benefits, or for the clock to start ticking for purposes of those benefits. That may be profit sharing, that may be the accrual of vacation pay. There may be other provisions within the employment relationship that don't really commence until you have completed the probationary period. Don't confuse the difference between the probationary period on a employment contract that is at will from the fixed term employment relationship to which you have a contract to work for a set period of time, begin date, end date, and here are the terms and conditions of that contract. Let's move on to the most common type of employment contract, and that is the employment contract that is at will. And in fact, in all states, certainly including the state of Michigan, the presumption when you have an employment relationship is that it is an at-will employment contract. That's always the starting point. We will presume the relationship to be at will. And there's a few things that you need to understand about the nuances, if you will, of the at-will employment relationship. The first of which is that the concept of at-will employment really permeates the totality of the employer-employee relationship. The employment at will doctrine applies to who it is that the employer chooses to interview for a job, who it is that the employer chooses to hire for a job, the span of control of that job, the rate of pay, who gets hired, who gets promoted, who gets demoted, and certainly the termination of employment. Understandably, one of the concepts of our lives that causes us anxiety is discrimination. There is a negative connotation to the word discrimination, understandably. But what is important to understand, I think, in the context of employment law is that we permit discrimination. In fact, within the law of contracts, at the core of the concept of freedom of contract is discrimination. We allow for people to pick and choose whom they wish to associate with, whom they wish to enter into contracts with. And the reality of it is, what we truly want in this world is we want people to discriminate in our favor. We want to get the job. We want to get the promotion. And we do permit discrimination. That's how we allow people to choose who to hire, who to interview, who to promote, who to demote, what rate of pay is to be allocated. What we do not permit is unlawful discrimination. And so what I want to make sure that as we go through this material is that you understand well the distinction, the difference between discrimination, which is permitted under the law, and unlawful discrimination, which clearly is not permitted under the law. And I would ask you to think about how you chose where to attend school. We are, self-included, alumni of Michigan State University, hopefully proud alumni of Michigan State University. And when our resumes are on a stack of hundreds, maybe thousands, we hope that the name Michigan State University resonates, that might give us a better opportunity to obtain employment as opposed to perhaps a graduate of another institution. And we recognize that there are people who have graduated from schools, call them the Ivy League schools, if you will, who have academic reputations that are thought of very, very highly. And that, in fact, perhaps they may get a job that we would very much like. I will say, as someone who is now long ago a graduate of Michigan State University, that my true belief is the farther out you get, the more it is about who you are, what you bring to the table, your attitude, your abilities, your competencies. But we do recognize that within the law of employment, as in all facets of life, discrimination occurs. And particularly with respect to employment law, what is problematic is when there is unlawful discrimination. And the distinction is quite significant. What is important to understand about the employment at will doctrine, at its core, the ability for the employer to discriminate in the hiring, firing, promoting, and demoting in span of control, rate of pay towards an employee. Because that's really at its core what employment at will is all about. Permitting the choices that employers make and allowing the employer to discriminate so long as the employer does not discriminate unlawfully. This doctrine, the employment at will doctrine, results in the presumption that the employer's actions are lawful until or unless the employee can establish otherwise. This is what we refer to as the burden of persuasion. The burden of persuasion is on the employee or prospective employee who believes that they have been discriminated against unlawfully to prove that the employer has indeed acted in an unlawful way. The starting point, the presumption is that the employer can make the decisions that the employer has made that have had a negative impact upon this individual or this group of individuals. The burden of persuasion, the burden of establishing that there was unlawful conduct is with the employee. And that's a tough hill to climb. That's a tough burden to bear. We have complete human resources departments that exist with one of the objectives of those human resources departments to make sure that the employer doesn't discriminate unlawfully, or at least when an employee is going to be, say, fired or demoted, that the reasons, the purpose of that firing or that demotion are not for some unlawful discriminatory reason or upon some unlawfully discriminatory basis. From the perspective of the employee who is seeking to establish that they have been unlawfully discriminated against, I would make the argument that over the course of the last 10, 15 years, proving these cases, while difficult, have been aided by the manner upon which we so frequently communicate now. Go back to when I entered into practice. People communicated verbally. Now communication is done much more frequently in the form of emails, texts, and things that are memorialized and, or at least potentially memorialized into more of a permanent form. This has made at least proving unlawful discrimination a touch easier, but it's still difficult to do because the presumption is that the employer has not acted unlawfully. The employer does have the right to discriminate. The employer does have the ability to make the decision that it has made. In fact, one of the most frequent questions that is asked of me by employees who have lost their jobs are, I want to sue, and I want to sue because I was discriminated against in a hostile manner. I was discriminated against unlawfully. And that, of course, necessitates me asking the question, what is the basis upon which you were discriminated against in an unlawful fashion? You know, if I bring you into my office and I fire you because you are 38 years old, and I think you're just too old for the job. 38, That's too old. You're fired. Is that discrimination on the basis of your age? Of course it is. I just told you, I'm firing you. You're 38, too old. Is that unlawful age discrimination? Well, under the Age Discrimination Employment Act of 1967, under the ADEA, the Age Discrimination Employment Act of 1967, under federal law, that would not be on its face unlawfully discriminatory, because the Age Discrimination Employment Act prohibits discrimination on the basis of age, with certain exceptions that we will talk about. But it applies only when an employee attains the age of 40. So while that would on its face certainly be what we would refer to as a prima facie case of age discrimination, the statute only protects employees once they have attained the age of 40. And so it is really important as we move forward to understand the distinction between what is discrimination, because there's always going to be discrimination anytime we pick one individual over another. That's not in and of itself unlawful. What is unlawful is discrimination in violation of one of the statutes that we will discuss, the statutory exceptions, if you will, to the employment at will doctrine. Including how the cases, most notably and most recently, the Bostock case, how the cases have interpreted the statutes for purposes of making application and determination of what constitutes unlawful discrimination. So we have the employment at will doctrine, which is presumed. And then we have the statutes that are exceptions to the employment at will doctrine, really starting with the Equal Pay Act of 1963, all the way through the state and local statutes and the way that the courts interpret what the legislative and executive bodies have carved out as being exceptions to the employment at will doctrine in the form of statutes that prohibit certain types of discrimination based upon the parts of the human condition that are really beyond anyone's ability to decide for themselves. Before moving to the statutory exceptions to the employment at will doctrine, let me again highlight that when an employer makes a decision that has a negative impact upon someone, the starting point, the presumption is that that decision is lawful until or unless the employee can establish that the decision of the employer was unlawful in violation of one of these discrimination statutes. The burden of persuasion is on the employee to establish the unlawful acts of the employer. Even then, and this is what makes these cases very difficult for employees to win when they bring a claim for unlawful employment discrimination. Even then, the employer has the ability to prove that the adverse employment decision, adverse upon an employee, that the decision was made for a legitimate, non-unlawfully discriminatory reason. And this is, if you will, kind of the second hurdle that an employee has to clear to be able to prevail on an employment discrimination case. One, that there was unlawful discrimination on the part of the employer. And two, that the employer did not have another non-unlawfully discriminatory reason for the actions or the decision that it made. And I can tell you, I have had plenty of cases through the years on behalf of employees where we've been able to sail right over that first hurdle, we've been able to establish that a statute was violated. But what we were unable to establish is that the employer was wrong in claiming that they had another non-unlawfully discriminatory reason for the termination of the employee. This is, if you will, the exceptions or defenses that can be applied to employment discrimination claims. And this is in reality why it is so very, very difficult for employees to win employment discrimination cases. Now, I might argue, in fact, I will make this point, that the purpose of these statutes that carve out what constitutes unlawful discrimination are twofold. Yes, they exist to provide someone who has been discriminated against the opportunity to seek recourse in court. But I would suggest that the other purpose, and perhaps the most successful purpose behind these statutes, is that they have caused a shifting in behavior amongst employers. If you judge the effectiveness of the statutes from the courthouse steps, you might have a really jaded, inaccurate perception of the effectiveness of law. You would think that all juveniles are delinquents. You would think that all marriages end in divorce. You would think that all employees steal from their employer. We have law in place to influence behavior in a way that benefits society. And so one of the impacts of the employment discrimination statutes has been to, over time, influence and affect the way that employers make decisions. And this is certainly a positive. We're certainly not where we hope to be as a society, but these statutes have played an effective role in making the workforce more inclusive, certainly, than existed back in the mid to early 1960s. Which brings us to the employment discrimination statutes. And in the lecture slides, I give you kind of a breakdown of the statute, where you can find the statute, a little bit more depth in the terms used within the employment discrimination statutes. But I'd like to go through with you at this point in time kind of an overview of the statutes that act as exceptions to the employment at will doctrine. And the exceptions to the employment at will doctrine really start with the federal employment discrimination statutes, but also recognize that states and local governments themselves have enacted statutes that put certain limitations on the freedoms that employers have to discriminate at will. When you look at the application of any discrimination statute, and really any act of discrimination, I think it is important to also recognize that discrimination occurs really in two different ways as a matter of law. You can have what we refer to as disparate treatment, which is when you have an act that on its face differentiates how we treat people based upon their gender or their age or the color of their skin. The local high school decides that it wishes to hire a new football coach. And historically, high school football coaches have certainly tended to be male. there increasingly are non-male high school football coaches, but over the course of the last 60, 70 years, predominantly that has been a male dominated job. The local high school who wishes to hire a new football coach puts a job posting, football coach position available, must be a man. Well, that's going to be very problematic for that school district. And that is an example of where we would have a act of discrimination, unlawful as it is, by treating similarly situated persons differently based upon how we classify them, male, female. That would be unlawful, and that would be an example of disparate treatment. Well, what if I were to instead put this job description together? Opening, high school football coach. We know that we cannot discriminate on the basis of gender, but in fact, we want to be very transparent in how we go about hiring the football coach. So this is what we're going to do. We're going to have a criteria, a standard that we apply, and we're going to give certain points based upon how the applicants meet the criteria that we have put forth. If you have played high school football, we're going to give you 5 points. If you've ever coached high school football before, we're going to give you 10 points. If you've ever played or coached college football, we're going to give you 10 points. And by gosh, if you've ever played professional football, you're going to get 15 points. And then we're going to total up the points, and we're going to hire the person who scores the highest based upon this hiring criteria. Notice that we didn't say that we're going to hire a man for the high school football coaching position. But what have we virtually guaranteed the outcome is going to be? As a lifelong football fan, I can tell you that whilst it is exciting to see non-male participants in the sport, historically, it's been a sport that has been dominated by boys and men who have played the game. So we're going to end up with the same outcome that we had in mind when we said, got to be a man to apply for the job. We're going to go through the nuances of appearing not to discriminate on the basis of gender, but the discriminatory impact of the criteria that we used are going to result in the exact same outcome. And this is certainly very problematic, and one of the things that exists in all forms of discrimination, and it's why at its core, when there is the concept of choosing, we have to look at the criteria that is utilized, because what you will find in organizations, in employment certainly, is there will be this belief even that there isn't unlawful discrimination because no one is intending necessarily to discriminate in an unlawful fashion, but that the impact based upon other factors that are utilized results in unlawful discrimination. And that is because the impact of what may seem to be neutral policies can nevertheless have unlawful and bad consequences when all layered and put together. The outcome would be the same as if we applied a discrimination in the form of disparate treatment. While certainly the civil rights laws that brought about the end of slavery and the putting of the union back together can be viewed and are articulated within law as being discrimination statutes or statutes that are exceptions to the employment at will doctrine. Really, the modern statutes that make up or comprise the statutory exceptions to the employment at will doctrine begin with the Equal Pay Act of 1963. Under the Equal Pay Act of 1963, the last law actually signed by then President John F. Kennedy, when men and women are doing substantially the same work, they're to be paid the same. While the disparity in pay between men and women in employment was about 51 cents that the woman was being paid for every dollar the man was being paid in 1963, has closed, certainly. And it's not nearly as significant a difference as we sit here today. But there is still certainly work to be done. The Equal Pay Act certainly played a role in highlighting the disparity in pay that exists in the workforce between men and women. Now, with each of these statutes, particularly with something like the Equal Pay Act of 1963, recognize that employers are always permitted to offer a defense that can be accepted under the law. And one of the defenses to disparity in pay is seniority. One of the defenses certainly can be that what may appear to be the same job is in fact different. Merit can result in differences in pay. So as I outlined for you each of these different statutes that carve out the statutory exceptions to the employment at will doctrine, recognize that there are defenses that are offered by employers and that we recognize exist as well. And we'll talk about those as we move forward. Bottom line, Equal Pay Act of 1963. If a man and woman are doing substantially the same job, they are to be paid the same. The Equal Pay Act of 1963, in many respects, greatly overshadowed, understandably so, by probably the most significant statute enacted of my lifetime, and that is the Civil Rights Act of 1964. Under the Civil Rights Act of 1964, it is unlawful to discriminate in housing, education, and notably Title VII in employment on the basis of race, color, religion, sex, or national origin. This is a statute that former Secretary of State Henry Kissinger referred to as the greatest foreign policy initiative enacted by the United States in his lifetime. And while it's a wholly domestic law, Kissinger made the point that it allowed him, when negotiating with other countries, to point with pride to, in the United States, we do not permit discrimination in housing, education, employment on the basis of race, color, religion, sex, national origin. The Civil Rights Act of 1964 really is the basis upon the whole concept of employment discrimination. Discrimination law in employment, or as it applies to employment, is really grounded in these concepts. The idea, the notion that we will allow for employers to pick and choose whom they want to interview, hire, promote, demote, fire, pay, span of control. We will give great latitude to the employer in making these decisions. But here's what's off limits. Here's not upon which or how the employer is to base hiring, firing, promoting, span of control, demotion decisions on the color of a person's skin, on their race, on their religion, on their color, or on their nation of origin. And while we will talk as we move forward in our overview of employment law and employment discrimination on each of these different protected classifications, I think it is important to understand that these protected classifications are protected within all facets of employment. Much like the employment at will doctrine applies to all aspects of the employment relationship, so do the protections afforded by Title VII of the Civil Rights Act. We will talk about changes that have occurred and changes that are likely to occur as Congress debates the protection of a person's natural hair style and color, not permitting discrimination based upon, again, factors of the human condition to which persons have little to no control of. How employment discrimination law works is that typically Congress, or within state government, the legislative and executive branches, will debate and agree upon that which we as a society will not tolerate by basis or by purposes of discrimination. A law will be enacted, and then over time, the courts will try to lend meaning as to what was intended with the enactment of the statute. And we see this within the Civil Rights Act of 1964, notably with two types of or theories of protected classification as carved out by the act, by the statute. You note that sex is a protected classification under Title VII of the Civil Rights Act of 1964. What is meant by gender discrimination, sex discrimination? Well, in the early 1970s, the Supreme Court, in a famous Meritor Savings Bank case, outlined that inclusive in protections against discrimination on the basis of one's sex should be protection against being sexually harassed as a condition of employment. And so by case law, interpreting the Civil Rights Act of 1964, we have carved out a whole theory of discrimination known as sexual harassment. That sexual harassment can be in the form of quid pro quo sexual harassment, or what is referred to as the hostile work environment sexual harassment cases. Most notably, fast forward now to 2020, in the Bostock case, the United States Supreme Court identified that not only is discrimination on the basis of sex unlawful when we talk about distinctions between male and female, but also we extend the protection to sexual orientation. We'll talk about these cases as we move forward, but I'm just trying to lay forth for you kind of the skeleton, the outline, if you will, of what constitutes employment law and employment discrimination and how it all works. The Civil Rights Act of 1964, and notably Title VII of the Civil Rights Act of 1964, do not apply to all employers. And in fact, the threshold is employers that have 15 or more employees. And in fact, there are exceptions to the employment discrimination statutes, as are outlined for you on this lecture slide. But I will note that where the federal civil rights laws typically apply to employers that have 15 or more employees, the state discrimination statutes usually then pick up the difference. And we have in Michigan, by way of example, the Elliott-Larsen civil rights laws enacted in 1976, which protect race, color, religion, sex, national origin from discrimination. But the civil rights laws in Michigan went forward and protected marital status, particularly in light of the Loving decision and the fact that we didn't want people discriminated against based upon who they married or the color of the skin of someone they married, or if they chose not to be married. And Similarly, in Michigan, we carved out protections from employment discrimination on the basis of a person's height or weight. The application of Title VII, as I indicated, is beyond simply just applying to termination of employment, but to all facets of the employment relationship. This is inclusive of, and notably inclusive of, payment, and has in many respects usurped much of what was carved out in the Equal Pay Act of 1963, although those two acts act still together in unison. One of the things that I will note for you is you can always tell when the government is serious about the enforcement of civil law, because an agency will also be established and funded for the enforcement of civil law. We have the prosecutor's office at the state level of government. We have the U.S. Justice Department at the federal level of government. And when there is a crime that is committed, one of the functions of government is the enforcement of the criminal code. But what about a civil violation of the law? How do we deal with those acts? It's not practicable for everyone who has been discriminated against to go hire a lawyer and file a lawsuit. Well, we have instead various different agencies that are established within government, the purpose of them being to facilitate a quick and cost-efficient method for the enforcement of civil law. And at the federal level, we have the Equal Employment Opportunity Commission, or known as the EEOC, that anyone who believes that they have been discriminated against in employment under federal law can file a petition with the EEOC or a complaint with the EEOC and see if through that process, the ending of the discrimination can be brought about. One of the aspects of federal law that exists is that, with the exception of age discrimination employment claims, other claims that are brought under the Civil Rights Act of 1964, before a lawsuit can actually be filed against the wrongdoer or the alleged wrongdoer, a complaint with the EEOC actually must be filed. That's a step that must occur prior to the filing of an actual civil lawsuit against a employer who has allegedly violated one of the federal discrimination statutes. I'm not going to go through, as part of this asynchronous review of employment discrimination, exactly the definitions of race, color, religion, sex, national origin. But I do present to you these lecture slides that outline for you kind of a accumulation of cases and how those cases have described each of these protected classifications. I will say, when it comes time to testing, I'm not going to be trying to drill down to the most subtle of distinctions that the courts have drawn on these, if you will, big five protected classifications. But I suspect, particularly any of you that, may struggle a bit with the English language or want further explanation about what exactly is meant when we talk about nation of origin, and what do we mean when, an employer might have a must speak English on the work site rule. How does this apply? Or, what exactly constitutes the difference between quid pro quo sexual harassment and the more, if you will, subjective concept of the hostile work environment? At its core, a condition of employment, much like a condition of attending classes, should not be that you are constantly bombarded or reminded of sexuality, and that as a condition of employment or education, that somehow there isn't an expectation of you based upon your sexuality. And if those are circumstances to which you are subject, that's unlawful. It needs to be addressed. It must be addressed. And particularly within the working environment, there's a 40 years now of case law that carves out these behaviors as being unacceptable pursuant to the Civil Rights Act of 1960, or rather of the Civil Rights Act of 1964. And in fact, right off of the EEOC website, I brought up some of the examples of what would constitute sexual harassment within the workforce. There have been amendments to the Civil Rights Act of 1964 extending what is protected from discrimination, or if you will, what constitutes unlawful discrimination. The first of these I referenced a few moments ago in the context of age discrimination. The Age Discrimination Employment Act of 1967, which is an amendment to the Civil Rights Act of 1964, extended as a protected classification persons who are 40 years of age or older. The idea certainly being that as a society, we recognize that people, once they have attained the age of 40, or at least back in 1967, we thought once they attained the age of 40, I think of that as being pretty young these days, that they have lesser time to save for retirement. We wish for them not to become dependent upon the social fabric of society. And we do not want somebody to be discriminated against in employment on the basis of their age once they have attained the age of 40. Now, I will tell you, this is one of those circumstances where the exceptions, the defenses, have really swallowed the rule. By way of example, when the 62-year-old employee who makes $150,000 is replaced by two 30-year-old employees, each of whom makes $60,000. A legitimate defense that the courts have accepted is, we didn't fire the employee because of his age. We fired that employee and brought in two other employees because the economic reality of it is we're getting twice the amount of work done and we're paying less money for it. And courts have accepted as an economic excuse that type of defense to the Age Discrimination and Employment Act of 1967. Again, it's not that the law hasn't been effective, because it did radically change the policies of employers, including Michigan State University, where typically there was a mandate that employees had to retire at 65 or 70. And most of those have gone by the wayside as a result of that statute. Rehabilitation Act of 1973 was the first protection under federal law of individuals that have disability. Under the Rehabilitation Act of 1973, any entity that receives federal funding, be it an educational institution such as Michigan State or an employer, anybody that receives money from the federal government is not permitted to discriminate on the basis of a person's a disability. And that statute was greatly expanded to all employers that have 15 or more employees under the Americans with Disabilities Act of 1990. Under the Americans with Disabilities Act of 1990, if a reasonable accommodation can be made for an employee that has a disability, you cannot use that disability as a disqualifier for purposes of employment. It doesn't mean that you have to hire someone who has a disability, but it just simply means that you cannot use that as a factor not to hire the employee if a reasonable accommodation for that disability can be made. More recently, the Family Medical Leave Act of 1993. If you have an employee that qualifies to take leave, at the conclusion of that leave, there can be no adverse action taken for that employee, and then that employee has to be placed back into the workforce with no negative treatment or result based upon the employee having taken FMLA. We'll talk more about that as we move forward. I would note that the great debate that took place with FMLA was who it would apply to. And you'll see on this lecture slide that FMLA applies only to employees that have been working for a business for at least 12 months, have worked at least 1,250 hours over the preceding 12 months, and for an employer that has 50 or more employees that work for that employer within a 75-mile radius of the location where the employee is electing to take FMLA. What is interesting about FMLA, and I think where people oftentimes miss the boat, employers oftentimes miss the boat, is the statute actually places an affirmative burden on employers to tell employees that they have the right to seek FMLA under certain circumstances. And we will talk about that as we move forward. There are also statutes that protect employees who are classified as, quote, whistleblowers, those who, for public policy reasons, have either gone forward or were in the process of going forward to divulge information about an employer that the employer believes to be such that it casts them in an unfavorable light, an embarrassing light. And we'll talk a little bit about, and I'll give you some examples of whistleblower statute cases. But the whole idea behind the whistleblower is we want people to tell the truth. We want people to stand up for and point out when there is injustice and wrong and unlawful behavior and unethical behavior. But what ends up happening oftentimes is in the short term, when somebody stands up and points the finger in the direction of an employer and says this employer is doing bad things, that the employee is punished. And so we create a cause of action for the employee when they believe that they have been retaliated against in employment because they have stood upon principle and have actually complained or are in the process of blowing the whistle on the behavior of the employer. When there is a establishment of a violation of one of these discriminatory statutes, this shifts the burden onto the employer to show that there is a defense to what appears to be unlawful discrimination. Bona fide occupational qualification. There are certain jobs where we will permit discrimination, even on its face, in violation of age, race, color, religion, sex, national origin. We allow for differentiation in the handling of employees based upon other criteria such as longevity or seniority, and even payment differential on the basis of merit. But these have to be legitimized. In other words, we can't just, pay differently in one location because it results in the man getting more money. Whereas if we use that same criteria in a different location, the employer would end up paying the woman more money. And so what we do is we apply, merit-based pay over at this one location, but on the other location, we pay, everybody the same. There has to be consistency within the workforce anytime you're going to violate the terms of an employment discrimination statute. And then, of course, and we will talk about this as we move forward in employment law, there is that second hurdle, really the most difficult thing for the aggrieved employee to get past, and that is the employer's proof that there were other legitimate non-discriminatory reasons for the actions that have had an adverse impact on the employee. When there is a finding of wrongful termination or discrimination in violation of one of these statutes, the available remedies include the payment of attorney's fees, which is different than in most causes of action in the American legal system, reinstatement, back pay, front pay if it's warranted, and even orders that the employer cease in engaging in the type of behavior that was deemed to be unlawfully discriminatory. As I noted, most states have enacted their own civil rights laws, very comparable to the federal civil rights laws. And these create state causes of action for employment discrimination, again, very comparable and similar to the federal causes of action for employment discrimination. And again, I will highlight for you the distinction between discrimination in employment, which happens all the time, and unlawful discrimination, which again necessitates that the employee come forward with evidence and establish the cause of action of unlawful discrimination as outlined in and permitted by these statutes. Which brings us then to the third type of employment contract, the third classification of employment contract. And this is the for cause or just cause employment relationship. The for cause or just cause employment relationship is very much an exception to the employment at will doctrine. When you have a for cause or just cause employment relationship, this is where the employer has chosen to be not an employer at will. This is where the employer has chosen not to accept the presumption of employment at will as permitted by law. Now, what would cause an employer to give up the status of being an employer that is at will? I mean, it's a deck that is stacked heavily in favor of the employer, because again, in the employment at will circumstance, the presumption is that the decision the employer makes is lawful until or unless the employee can prove otherwise. Why would the employer give that up? Why would the employer choose to be a for cause, or if you will, just cause employer? By the way, for cause, just cause, same thing. Well, first of all, sometimes it's not quite as much the choice of the employer as it would seem. Where you have a collective bargaining agreement, where you have a union contract, perhaps the key provision of a collectively negotiated contract, a union contract, will be for cause employment for those who are covered by the union contract. So that's one of the things that oftentimes is negotiated where you have union representation, that no longer will this group of employees be considered to be employees at will. They will now be considered to be employees that can only be terminated for cause. Sometimes employers will just actually choose to be employers for cause. And here's what for cause employment means. It means that when an employee believes that he or she has been discriminated against in an unfair, imprudent, unlawful way, that the employee can make that allegation, they can make that charge of their employer, and the employer will take on the burden, the responsibility of establishing that the decision that the employer made was legitimate for a justified purpose. It flips, if you will, the burden when the question of discrimination arises. I'm repetitive, and I know that I am. I'll say the same thing many, many times, but it's because I believe it to be important. Within the employment relationship that is at will, which is the norm, which is the majority of employment contracts, the burden is on the employee to establish that the employer has acted unlawfully. When you flip the switch and the relationship is a for-cause employment relationship, the burden is on the employer to establish the legitimacy of the decisions that it has made that have had a negative impact upon the employee. And that's quite a difference. But certain employers have made the conscious decision to recognize that they only want decisions made that have a negative impact upon an employee for legitimate reasons. I had one employer tell me one time, we always have to actually justify the reason that we have demoted or fired somebody anyways. We might as well just take upon ourselves internally the burden of establishing that our decision was correct. Because within for-cause employment, what happens is that the decision, when it is questioned by the affected employee or group of employees, the decision is turned over to a neutral decision maker who will decide if the rationale offered by the employer is legitimate. That neutral decision maker might be an arbitrator. That neutral decision maker might be a group of similarly situated employees who will pass judgment on the decision of the employer. The key is it has to be a neutral decision maker. Some of the questions that, of course, will be asked will be, was the employee forewarned about the consequences of his or her actions that might have been punished? Is the punishment commensurate with the behavior of the employee? Was the decision made for a legitimate business reason? Or was this a decision that was made based upon some other non-legitimate business decision that needs to be undone? The key is that when the decision is ultimately judged by this neutral decision maker, whether it's an arbitrator or a neutral committee, the decision of that neutral decision maker is final. So if the employer is correct, it basically makes it next to impossible for the employer to be sued. And if the decision of the employer is incorrect, then the employee will be reinstated, and the same remedies that we talked about a moment ago would be available. Back pay, future pay, attorney's fees. It creates a measure of transparency in the decisions that an employer makes that have a negative or potentially negative impact upon employees. That's the basic outline of employment law and employment discrimination. And what can happen oftentimes is we lose the forest for the trees, which is why I like to start with the forest. I like to start with, this is the purpose, this is the organization, this is the law. And as we move forward, we can look at some cases and some circumstances, both historically about the evolution, if you will, of employment discrimination law, the state of employment discrimination law today, and where employment discrimination law is likely headed, factoring in also in the labor statutes and how those impact the employer-employee relationship, particularly when you then have a collectively bargained for employment contract. But that is good for a start, I hope. Please reach out to me if there's anything that I can do for you, any questions that you have.